Welcome to today's event, everyone, Modern Shifts in Religious Liberty Law. My name is Sarah Legner, and I'm one of the programming directors here in FedSoc. On behalf of all of our officers and members, thank you for joining us today. We're fortunate today to have both Mr. Sterrett and virtually Mr. Hahn joining us for this discussion. Mr. Sterrett is a partner at Dalton Tomich in the Illinois office, which he oversees. Dalton Tomich is a firm that specializes in religious land use and zoning law. Prior to joining the firm, he was in private practice here in Chicago at Malkin Baker. He is a member of the Alliance Defending Freedom as well as the Christian Legal Society, and he graduated from Regents University School of Law. Mr. Hahn has joined Beckett in 2019 and has already made quite the splash. He's also a non-resident fellow at the American Enterprise Institute. Before joining Beckett, he was also in private practice, specializing in appellate and antitrust law. He received his BA from American University, his JD from the Catholic University of America, and he clerked for both Judge Janice Rogers Brown on the DC Circuit, as well as Judge Hinton on the the United States District Court for the Eastern District of Virginia. So without further ado, we're going to go ahead and turn it over to you, Mr. Sterrett. Thank you.
Thank you virtually, and thank you here in present. It's wonderful not to have to do this via Zoom. Zoom had some novelty last year, but I think we're all kind of tired of it. And so it's good to see you all in person, even with the masks on. And also nice to meet you, Mr. Hahn. Look forward to hearing from you. And a good religious liberty presentation is much like jazz. You have to kind of riff off of one another. So I don't know if any of you guys are jazz musicians, but this is my first little duet with Mr. Hahn, but we'll see how we can interact on this. But just wanted to give you some personal and professional biographical information that will give you context for where I'm at today and how I got here. So I was born and raised in Roscoe, Illinois, which is over by Rockford, which is kind of the middle of nowhere, middle America. And went up through school not thinking I was going to be a lawyer. I actually majored in French, so I have a bachelor's degree in French. And then I got to the end of my college thinking, all right, well, I'm going to get a bachelor's degree in French, a minor in classics, and I love language. So what am I going to do with myself? Because I really don't want to end up being in a high school teaching French to, in my class, I was the only guy in my French class. So I was kind of fearing that this was going to be my life. I had lived in France. I loved French. I loved language. And then I met an attorney. And the attorney is trying to help me career-wise. And I said, I really love language. And he said, oh, well, that's what I do. I'm an attorney. And as an attorney, we use language to help people. And when he kind of framed it that way, he said, hey, use language to help people. So that's kind of what got me to go to law school, still not knowing really what I wanted to do when I was in law school. And all of a sudden went through the whole experience. This was right before the economy kind of crash and the recession. So there were still kind of prospects of jobs and thoughts of getting one. And so I ended up graduating and got a couple offers and then went and started working at Malkin Baker in Chicago. And some attorneys or some law students, you guys go into law school knowing I want to go into politics, or I want to clerk, or I want to go into trademark, or whatever it is. More power to those that have a firm conviction already of what they want to do. I didn't have that firm conviction. I just was trying to figure out how I could use language and my law degree to help people. And I got a job at Malkin Baker. And first week I sat down with the founding partner, and I realized that one of the main areas, practice areas of the firm was Religious Land Use and Institutionalized Persons Act work. Now that's a mouthful, and it's kind of a wonder, well, how did you get into this? So I sat down with the founding partner of the law firm and I asked him, I said, all right, well, tell me the story. And he started talking about this small little church, a group of Pentecostals out in Rockford that bought an old school building and they wanted to meet on Sundays. It's a school building that had been vacant for a while. And then all of a sudden the neighbors said, oh, we got some crazies that are moving into this old school building. We can't have them meet there. We've been used to this quiet, vacant school building next to us for many years. Now all of a sudden we've got people in the parking lot, and they're probably weirdos, and they're probably going to erect some type of 12-story prayer tower. So they get the zoning involved and they shut down the church. And then, so Mr. Mauck ends up getting brought into this case. And it was one of those situations where the pastor actually called Mr. Mauck and said, hey, I see you're a member of the Christian Legal Society. God told me you're going to be my attorney. And I don't know if you've ever had that happen to you, but it's kind of a hard call to take if you're an attorney and somebody calls up and says, God's told me you're going to be my attorney. So Mr. Mauck tried to be diplomatic and he said, look, I don't litigate. I don't do anything out in Rockford, and I need to get paid. And it looks like all three are strikes against you. And the pastor just as clear as day said, no, God told me you're going to be my attorney, and just essentially hung up. Well, so Mr. Mauck, not wanting to spurn God, I think he was more than willing to spurn the pastor, was just like, oh, what do I do? And so lo and behold, he took a chance and said, okay, well, I care very much about religious liberty. So he went to the pastor and he says, I need you to find me a local litigator because he needs to help me litigate this case. And I need you to find somebody, and I'll take this, but you're going to have to find a way to get me paid. And long story short, it went into all the way up to the Court of Appeals in Illinois, and it made some substantial law protecting religious assemblies in Illinois. So based on that, Mr. Mauck kind of ventured off into a religious land use practice. This is an example of how your law practice will likely find you while you're looking for something. So even if you may not feel like you know exactly what you want to do, continue just to do what's in front of you with the best you can. Be open to the opportunities that come. You're going to be presented with opportunities, probably far more than I was presented with, because you guys have a wonderful school and a great reputation. But sometimes a lot of what you guys are thinking, maybe the practice that you want to go into, it's going to turn out that an opportunity will present itself, and all of a sudden you'll be the expert on some niche area of the law, and so I just encourage you on that front. So bring that back to how I got into this. All of a sudden, after Mr. Mauck finishes the story, he notices that I'm tearing up because that was the church that my parents were going to when I was 5 years old. So all of a sudden I had this arresting feeling like, oh my gosh, I was pursuing French. I had no idea that this was where I was going or what I was going to do. But now all of a sudden I'm sitting here, and my new boss of 1 or 2 weeks old, he was the attorney representing my congregation, the bunch of weirdos in Rockford. And now all of a sudden I find myself working for him, and he didn't realize that when he hired me. So like none of this was disclosed. I usually don't put my, the church that I attended when I was 5 years old on my CV. But all told, all of a sudden I realized, hey, this is an amazing opportunity. So I got involved in the Religious Land Use and Institutionalized Persons Act litigation, not because I pursued it, but because in some sense I felt like, man, this is where I'm supposed to be. And so for the last 14 years, I've been filing civil rights suits against municipalities, alleging free exercise clause claims, RFRA claims, and religious land use claims, defending the rights of all different faith groups to have a right to assemble. And I can say, and we'll bring this up to speed on the religious liberty and kind of where we're at today, I wouldn't have a practice, a religious land use practice or a RLUIPA practice. And I was kidding with you before, the way we pronounce it, the practitioners pronounce it, is RLUIPA. Judge Posner always had a fun time when you would argue a RLUIPA case in front of him on the Seventh Circuit. During the course of the argument, he would pronounce the acronym 3 different ways, and just to kind of play cat and mouse with the attorney. And so it kind of grates on me. So if you want to say it, we say RLUIPA. But I wouldn't have that RLUIPA practice if it weren't for Justice Scalia's Employment Division versus Smith decision, which was such a encroachment on the religious exercise, or a shift as to free exercise jurisprudence, that Congress, a unanimous Congress, leapt up and said, hey, let's do something in unison, which never happens anymore. And they said, we have to protect religious liberty. Where are we going to protect it? Well, definitely in the institutionalized persons context. Beckett actually had an argument this morning, which I wanted to listen to, so I can't wait to listen to when I get home. And the land use context. And the land use context was key. Chicago was one of the main offenders, frankly, the city of Chicago, in terms of discriminating against religious land uses. And so Mr. Mauck testified before Congress in support of the Religious Land Use and Institutionalized Persons Act. And I must say, Mr. Mauck is also a University of Chicago law grad. So all that to bring you to where I'm at today. So for the last 14, 15 years, I've been litigating religious land use claims and butting my head up against Smith over and over and over again. And I'm excited about where the religious liberty jurisprudence is headed. I'm not satisfied with where it currently is. We can discuss where it is. Mr. Hahn can relay something, probably a lot more as to the cases that Beckett has actually handled. Most of my cases are just before the 7th Circuit, the 8th Circuit, the 11th Circuit. But I litigate cases all in district courts all across the country, because I usually get a call from a pastor or a rabbi or someone at a mosque saying, hey, they denied me zoning. I have no idea what to do. Do I have any rights? And we come in and fight. So that's some background. Mr. Hahn, do you have anything you want to provide in terms of your background? And then we can discuss how to take it next and kind of bring everybody up to speed on religious exercise.
Sure. Thank you for that. Let me just apologize for not being with you all in person. I too am zoomed out, but today, nonetheless, here I am in Zoom, and hopefully I'll get an opportunity to join you all for what, having grown up in Connecticut, I have to refer to your pizza as a sauce pie. Nevertheless, I hope to come and enjoy one. But I will say that I was grateful to get to talk about what kind of personally led me into religious freedom, and then connect that to where the jurisprudence is, because that's certainly how I think about it. Really, my interests, I did not go to law school intending to litigate religious freedom cases. But like is said in other contexts, I didn't choose this, it chose me. And that is very much how I kind of view how I ended up at Beckett. My time at law school, I graduated from CUA in 2012. My time there coincided with what is an ongoing shift in religious liberty jurisprudence in a number of respects. While I was there, the Supreme Court began hearing a number of cases that called to question the rights and the roles of religious institutions in public life, as opposed to religious individuals. For most of the 20th century, the kind of landmark, not just free exercise, but Bill of Rights cases more generally, involve individuals as opposed to institutions asserting their freedom against the government. And that's certainly the fashionable way in which people talk about Bill of Rights guarantees. It's certainly the way in which many Bill of Rights guarantees are lionized as individuals asserting their freedom against the government. And I am not here to suggest that that is a bad thing or a wrong thing. That is important and necessary, and it happens frequently to this day. But nonetheless, there was a marked shift that began happening in the 20th century, acknowledged even in some of those earlier cases, that simply the nature of what we presume government should be doing in our lives and the responsibility and authority that's been given, particularly to the federal government over the past 60 years, had really kind of accelerated to the point that when I was in law school, nonprofit healthcare ministries, for-profit corporations that are closely held and have a religious identity, religious schools, foster and adoption agencies, campus ministries, all forms of institutional manifestations of religious exercise began seeing their role in the public square questioned and challenged in court. And this shift, like I said, was happening while I was in law school. I was working as a research assistant for Mark Rienzi, who is a professor at Catholic, and he's now the president of the Beckett Fund. He joined Beckett during my second year, during the time of the contraceptive mandate cases involving the Little Sisters of the Poor and Hobby Lobby being the two most notable, though there were many. And that shift from the emphasis on the individual to the institutional wasn't just a legal shift. It's not just a matter of legal doctrine that's raising these new kinds of questions, but also it's a cultural shift. We're seeing a shift in the role of institutional religion in public life, whether people regard institutional religion as necessary for democratic self-governance, and also whether people participated in themselves personally. And like I said, this was very much a personal development for me, because it was really in law school where I began to see for myself the kind of formation that institutional religion in particular really demands, and it begins with an invitation, but ultimately challenges individuals to engage in, to make themselves formed in a way that are capable of freedom. And this goes to a very fundamental issue within liberal society, which is, how do you understand the nature of the human person and their rights? Do you understand the human person as fully formed, rationalistic, who is someone who's capable of just making choices, and everything that they do is legitimate because they chose to do it, and they're totally capable of making good choices just on their own? Or do you see the human person as broken, good but broken, and therefore not good enough, and in need of refinement and formation before one can really choose not just any old thing, but the good thing? And what kind of relationship does those two understandings of the human person have to a free society? I would submit that the founders understood a really robust role for religious institutions in particular in shaping and forming people in the virtues of self-government. I think that role was observed by someone like Alexis de Tocqueville in writing Democracy in America. And that formative role for religious institutions was often presumed, and it was presumed to such an extent that Employment Division versus Smith was mentioned, that for a long time, and Smith says this quite clearly, that we could presume solicitude toward religion in a free society. We could presume that democratic legislators accountable to their constituents, who themselves have been exposed and formed in religious assembly, would be solicitous of the role that religion plays in preserving freedom, limiting government power, and providing an explanation for the source of our rights. We can't presume that anymore. And it's because of these shifts in the role of institutional religion, doctrinally, culturally, personally, that really, to me at least, very much kind of converged during the time that I was in law school, that are leading to these new kinds of questions that we're seeing come up over and over in different ways in the court system. And I think Smith on the one side and Fulton on the other provide kind of good examples of the two aspects of that shift and where we could be going. Happy to get into that in any more depth, but also happy to proceed however my dance partner wants to go next.
I thought we were doing jazz, but if we want to dance.
Okay.
Yeah, so I think maybe we can just summarize the last 100 years of free exercise jurisprudence in a couple of minutes, and then talk about where we're at today. So historically, while America is the home of the free, there's also been a substantial amount of religious persecution, and but it was generally a place where it was the land of the free, in the sense that government was pretty small, historically speaking, from the first 100 years. The federal government was very small. In fact, I watched a documentary on prohibition, and there was a time that 1/3 of the federal revenue had come from alcohol tax, which is pretty remarkable. It shows you just how small the federal government was at a certain time. But as the federal and state and local governments start to expand, all of a sudden what that does is it creates more flashpoints for conflicts with how we live our lives. So all of a sudden, the Mormon issue became a big deal. So in the Reynolds case, what are we going to do with polygamy? And so that's where there were religious liberty cases, but there really wasn't a lot of concern over whether or not we can, as a government or as a society, ban something that was kind of a central tenet of a particular religious group. So all of a sudden, the Reynolds case was decided, and then you start to walk through, the Supreme Court starts dealing with, okay, well, it's not just there's more pluralism going on in America. There's more diversity. The faith groups we're seeing more immigration from different groups. And as society diversified and there was more religious pluralism, there's both the need to protect the minority faith groups, but also the concern of, it's kind of I think Justice Alito put it this way, it's the bureaucrat's common refrain is, if I make an exception for you, I'm going to have to make an exception for everybody. And so then, as the court had to wrestle with this idea of, well, how do we make accommodations? Do we have to make an accommodation? When do we make an accommodation? And I think the accommodation cases are really the trickier ones, because I think you can see unanimity in the court on issues like, can a Catholic church have complete control over who its minister is? So there's a sphere of authority type argument. Those are questions that I think all 9 justices tend to agree on. The scope of that, well, who is a minister, that may be a different question. But there's been this recognition that, okay, there's these spheres of authority. Another thing my firm does is we do denominational schism cases where we represent a congregation and it's fighting with the denomination. It's a fight over property. Well, how do we deal with that? Those cases, I think we can put to the side as well. And then the other type of case that I think is easier for everybody to get behind is when then there's disparate or unequal treatment. So are you singling out the Muslims and not treating them the same way as the Christians, or singling out the Jewish congregation, but allowing a school? So I think most people can get their head around an agreement that we shouldn't be treating groups differently based on their religious belief, denominational affiliation. Where I think the problem comes in most of these cases is when somebody of a certain particular religious belief is asking for essentially an accommodation or an exception to a generally applicable rule. And historically, what happened, and I think the apex of free exercise jurisprudence went through Sherbert v. Werner, where the court recognized even indirect burdens on your religious exercise have to satisfy strict scrutiny. And then in Wisconsin v. Yoder, I think is the next step, where I think it was even a $5 fine that was imposed on the Amish for violating the compulsory education requirement. And so at that's kind of where everybody can kind of say the halcyon days of Sherbert v. Werner and Wisconsin v. Yoder. But what ended up happening was, okay, the religious groups can come into court asking for a religious accommodation or exception. And that immediately shifts the burden over to the government to show compelling interest and narrow tailoring. So what you would often see in the district courts, and I think what led to some of what Justice Scalia did in Employment Division versus Smith, was they said, well, now all of a sudden the district courts and some of the courts of appeals are starting to water down strict scrutiny. So they're finding a compelling interest. It's much easier. And I think Justice Scalia was very much concerned about the watering down of strict scrutiny because it applies in other contexts. And was very much concerned with this idea that, is this really the originalist understanding of the free exercise clause? Do people of faith have some type of right or special solicitude that entitles them to an accommodation or exception from a generally applicable neutral law? And so everything kind of shifted when Employment Division versus Smith came down, and that's the Peyote case. And it sent everybody kind of in a panic. I was too young at the time, and I believe Mr. Hahn was as well. So we weren't part of the panic, but we know people that were part of the panic. And they were saying, what does this mean for our clients and the faith groups that we represent? The ACLU said, we represent a lot of institutionalized persons, and their religious exercise has long been put to the side, and they're not allowed to have somebody with them when they're executed. They're not allowed to have their diet. They're not allowed to, and they came up with all this evidence, and Congress said we have to do something. So they passed RFRA, and which was struck down by the Supreme Court as applied to the states, but it still applies to the federal government. And then they said, well, we still need some protections, because if we're going to be living under a regime where a jurisprudential regime where generally applicable laws that are neutral with respect to religion can burden religious exercise, and there's no recourse, then we're going to find our religious liberty largely cabined in many contexts. So there was this odd coalescence between groups that say, well, we know one context, which is land use and zoning. So like my church growing up, it had really no free exercise claim under an employment division versus Smith analysis. The county could say, hey, this zoning law has nothing to do with religion, and it's generally applicable, so you lose. And following employment division versus Smith, that's largely as a private practitioner representing clients. It was very hard for us to even justify asserting a free exercise claim, because so often was the case that a district court judge would just say employment division versus Smith, stamp, out. And there wasn't much analysis. Now, I don't think that was really doing justice to employment division versus Smith and just what Justice Scalia was trying to accomplish there. Judges were far too eager to find that a law was generally applicable. And I think the Supreme Court tried to readjust the measures, so to speak, in the Church of Lukumi, Babalu I case, stressing that this is what we mean when we say generally applicable. And so that's essentially the free exercise jurisprudence that I had to deal with as a new associate, litigating under employment division versus Smith and Lukumi, trying to explain to the district court or the Court of Appeals, hey, look, this means something. And this law is not generally applicable because look, here's some exceptions, or here's an individualized assessment scheme that they've created. And oftentimes they just failed. Those claims just failed. And, for lack of a better claim, we really have to rely on a Religious Land Use and Institutionalized Persons Act claim or a RFRA claim if we had one. And I think what I saw among practitioners is we actually started to couch some of our religious exercise claims into free speech claims, because it was very helpful. And there's some language in employment division versus Smith about hybrid rights, but you don't find a lot of district courts finding hybrid rights claims. So there was just a lot of confusion, a lot of frustration about presenting a religious exercise claim in court. And then there was just a slow shift. And I'm an impatient private practicing attorney who would like some clarity so that I can advise my client with certainty as to how their free exercise claim is going to be adjudicated. But so far, the courts continue to deprive me of that certainty. And, but I've watched an incremental shift to some of the more recent cases that ADF and Beckett have won at the Supreme Court. And so maybe I can shift it back to you, Mr. Hahn, and you can explain about these shifts that have gone on since then and some of the big cases that leads us to Fulton too, if you want to bring us up, and then we can talk about the aftermath of Fulton and where we go from here.
Sure. So yeah, I generally kind of agree with that overall take on how things have moved in terms of our commitment to religious liberty. I will say, though, a couple of points. One would be that while I think at the founding, we had, for that time, certainly an unrivaled commitment to religious pluralism, even then. And I think that's borne out by the ratification history surrounding the Free Exercise Clause. There's statements during some of the ratification conventions that the Justice Department actually did a really interesting study of the history of the Free Exercise Clause during the Ed Meese Justice Department. It was featured in an amicus brief from Mr. Meese in the Fulton case. And one of the points it discussed was just the evidence at ratification about the acknowledgement that there was unrivaled religious diversity in America at the time, and that more was to be expected. And this commitment to religious pluralism was something that was considered to be generally a good thing, in that and I think James Madison is a good expositor of the kind of theoretical underpinnings for this, that it recognizes, as was said well by Mr. Street, as a separate sphere of authority that exists on earth. Madison's Memorial and Remonstrance Against Religious Assessments has this great language on this point, that every single person has a duty to the Creator that is precedent both in order of time and in degree of obligation to those to political society, and that one does not enter political society by surrendering their commitments to that other jurisdiction, let's call it, but rather retains their allegiance. And political society should therefore be shaped as much as possible around one's religious accommodations. And we see a long tradition of that in our political society. Some notorious and unfortunate exceptions. You pointed out the instance with the Church of Jesus Christ of Latter-day Saints in the late 19th century as one such example. But even then, the courts, as was rightly pointed out, was not generally getting into this until the mid-20th century with the growth of the federal government. And the case West Virginia Board of Education versus Barnett is helpful to point to in this regard. This dealt with Jehovah's Witness school children who were compelled to forcibly salute the American flag. And this case, Barnett, had reversed a decision issued just 3 years earlier called Gobitis, which upheld the authority of jurisdictions to force Jehovah's Witnesses to violate their conscience in this way. And one of the observations that was made in Barnett in reversing Gobitis was an acknowledgement that the power of the government has grown dramatically since the 18th century, that this calls into question how we have to understand and calibrate our fundamental rights in light of the current growth of government power, because we can't give up on our political traditions. At the same time, there's been a marked shift in how they're filtered through government power. And so the judiciary can't just stand pat and watch our principles be eroded while the role for government changes simply because the role for government has changed. And it is meant to be in that way a reversal of this idea of from Gobitis, that a proper understanding of the courts is to simply be disinterested in our political tradition. And that is a helpful way, I think, to understand Employment Division versus Smith, because Employment Division versus Smith did something really amazing. Instead of relying upon the vast majority of 20th century free exercise jurisprudence, it recharacterized nearly all of it. And in ways that, as was pointed out by Mr. Street with regard to hybrid rights, lower courts don't even take all that credibly, and instead explicitly relied on Gobitis, explicitly cited this reversed case to suggest that, well, regardless of what our political tradition may be regarding religious freedom, that's just not something the court should be interested in. And tellingly, Smith did not conduct any kind of historical inquiry to come to that conclusion. There's a footnote, rather curious, that historical analysis in an opinion by Justice Scalia was limited to a footnote, but essentially said that, well, there's a permissive interpretation of the free exercise clause that the Native Americans, Smith and Black, are advocating, and there's a different one. And ours, and this is language from the opinion, must be preferred because the alternative of judges routinely accommodating religious believers under the free exercise clause would be, and again, this is a quote from the opinion, horrible. That's footnote 5, if you doubt that. But that also, like I said in my opening comments, presumed, and it's explicit presumption, that one can expect democratic society, this was Smith, to be solicitous of the value of religion in its legislation. But again, that presumption says something about the nature of the political culture. It also says something about the nature of lawmaking, that there would be these general rules that would be enacted by legislatures. And I'm sorry, my email keeps going off here. Let me turn that off. that there would be these general rules enacted by legislatures, and that would be like the kind of bedrock baseline of most government action. But the ensuing 30 years, or the subsequent 30 years from Smith, puts a lie to those things. That's just not, whatever may have been intended by Smith, that's just not what's happened. Instead, what the cases that have reached the Supreme Court in more recent years show is that most of the time it involves administrative decisions, whether it be rulemaking decisions out of a government regulatory body. In the case of Fulton, a decision made by a human services commissioner at the local level just minutes after a meeting with the religious agency, or a human rights commission in the case of Masterpiece Cake Shop, administrative enforcement, like in the case, or the Equal Opportunity Enforcement Agency in the case of Hosanna Tabor. So over and over again, or private litigation involving selecting religious ministers. So these are not generally applicable rules enacted through the democratic process. And even perhaps Smith's chief academic proponent, Philip Hamburger, who did really kind of came out of the bullpen academically and tried to give an originalist argument in favor of Smith. He wrote a Notre Dame Law Review piece in 2015 that made the point that Smith's rationale breaks down, given the fact that there is so much administrative action that happens, that in those contexts, the kinds of considerations that administrative actors consider, the nature of the regulatory process, the kind of presumption of solicitude that Smith relied upon just simply doesn't make sense in that context, just not responsive to most government action in 21st century America. And so all of this really does kind of come to a head in Fulton. Unlike Smith, you were not dealing with an across-the-board criminal prohibition. You were dealing with a result in search of a rule to go after Catholic social services. It was not enacted through the democratic process like the criminal statute or the unemployment benefits and criminal law in Oregon, but rather a decision made by the Department of Human Services in Philadelphia in a meeting with Catholic social services. It was not generally applied, which is to say that there were exemptions made in the city's contract from the non-discrimination requirement for all sorts of reasons, because in foster care, you are making intimate, detailed lifestyle assessments for placing children with families. And so you're necessarily going to be considering things that you wouldn't be considering if you were to walk into a sandwich shop, for example, or buy a train ticket, or in my case, try to go and buy a plane ticket to Chicago. You're necessarily going to be considering things that are much more personal than that. And so all of a sudden, these arguments about religious accommodation coming from the political process just aren't responsive. And I think, as Mr. Street was pointing out, since Smith, you've seen a more kind of careful articulation by the court that Smith was not meant to be the grand unified theory of the free exercise clause, although I think there's some reason to think that that's how it understood itself, but in fact was meant to be a residual rule that covered what is in reality a very narrow set of circumstances when you genuinely have an across-the-board criminal prohibition with no evidence of non-neutrality toward religion. In some ways, you could draw an analogy to where maybe Smith's aspirations, let's say, to the aspirations of a test that for a long time had governed the Establishment Clause called the Lemon Test. And the Lemon Test attempted to regulate once and for all how government could be neutral toward religious displays in public life, manifestations of religion in public life. But the result of that was, despite thinking that there would be clarity given in one grand unified test, what actually happened was a lot of complexity because the test was not responsive to the real world. The test was not responsive to the diverse myriad ways in which religion and government interact in a free society. And I think the Free Exercise Clause is slowly bearing out that recognition as well. And the result of that is increasingly looking similar to where cases like American Legion and Town of Greece in the Establishment Clause context have suggested, which is a moving away from what the court has derided as rigid formulas and grand unified theories, and more toward a history-based, tradition-based more context-specific analysis of religion and government, and how much and how little they can interrelate in those spheres, on top of Smith's questions about, were you hostile to religion? Were you trying to single it out? Is this generally your policy? Do you really apply that to everyone, or do you create exceptions? Is this an individualized system? And so I think what you're seeing is a much more nuanced doctrine than perhaps Smith anticipated. And I think that increasingly leaves room for the development of a respect for history and tradition. And that played some role in Fulton as well.
Yeah, and I think, you have anything further to add, or do you mind if I?
Oh, please go ahead. No, I was, yeah, my silence was meant to be an overture. We haven't quite perfected our jazz dance moves yet. So we're not quite reading each other's feet.
That's fine. So yeah, so we were all waiting in anticipation for Fulton to be briefed and decided, and it was just kind of very interesting to see how, when the Fulton decision hit, just, I don't know, getting all the 100 pages and figuring out where everybody, what category they fit into, and it was just fascinating. Because it was definitely a win, but for my purposes, it was kind of frustrating, because I think, again, as a private practitioner, I've got clients that say, well, how do I have any certainty as to my free exercise claim? And I said, well, look, right now, there's enough votes on the Supreme Court to undo Smith, but there's not enough votes to tell us what's going to come after. So we've got this split. We don't necessarily know where everybody stands. Justice Barrett and Justice Kavanaugh wrote separately to indicate that, well, we can decide this under Smith, so there's no need to go that far. And we've got some concerns that we don't need to decide here. And we really appreciate Justice Alito writing what probably could have been or should have been the majority decision, and spending so much ink on why Smith was wrongly decided. But we're not willing to put our votes in that column quite yet. So now we're at a situation where religious liberty has been on kind of a winning record at the Supreme Court. There's this understanding that, no, we have to be able to protect people of faith and institutions. Institutions have made a lot of great victories lately. And we can't just have this kind of wooden interpretation of employment division versus Smith, which frankly led a lot of district courts, in my experience, to just kind of shoo away religious free exercise claims. That was just kind of what it was. Some judges don't like religious exercise claims. They're skeptical of them, and I understand why. I mean, it's this COVID and the vaccine exemption thing has me speaking to a lot of different groups. I spoke to a group of about 140 in a Swedish pancake house in Rockford a month ago. They all wanted to know, how do I get a religious exemption from my vaccine requirements? And somebody had told me on Facebook they have a guaranteed free exercise right not to, to tell my employer to get lost. And I'm like, no, don't listen to your Facebook scholar. He doesn't have it right. And frankly, there's some confusion here, and you don't think your rights aren't as rock solid as you think they are. And, and then one lady raises her hand, and, she's just like, so what should I say my religious belief is? And I was just like, no, that's not how any of this works. It's our sincerely held personal religious beliefs. You don't borrow mine. I'm not going to tell you mine. And I don't know what they would have done to me if they found out that I had been vaccinated, but it was it's just one of those situations that once people, and I think one of the concerns is, and I want to address this because I think when Justice Barrett and Justice Kavanaugh, when they write in their decision about, we have to figure out where the balance is. So do we require strict scrutiny in all cases? Are there places in which we should have some type of other type of scrutiny? Where we're at, I can understand the unease, because when I get a case, sometimes when we win a case, for example, I'll win a religious land use case, and it'll be notice will go out in the local paper. The synagogue or the church overcame the zoning board, won against City Hall, and then all of a sudden I'll get this call it's almost invariably from somebody else that was denied zoning. And like I got one from a lady, and I won't tell what state, but she's like, I own 100 mobile homes. And I was just wondering, and I was denied zoning by the same group. Can you take my case? I said, okay, look, tell me more about this religious component of your mobile home park. And she couldn't, but she's like, what if? Now hear me out. What if we call this? And I already knew where she was going, which is, help me, attorney, figure out some way to spin this as a religious exercise thing. And that's kind of the danger here. And you see it with the vaccine mandate exemptions. You see people that don't like government abuse or overreach for political reasons, for individual liberty reasons. And if this free exercise clause becomes this magic out that people can latch hold of, you're going to have what Justice Gorsuch called, when he was on the 10th Circuit, people perpetrating a fraud on the courts or their employers. And really, the courts have a very limited role with respect to judging whether or not somebody's religious beliefs are sincerely held. That's really what it is. Justice Gorsuch says the only role of the courts is not to determine whether someone's religious belief is valid, rational, supported by science. That's not the ken of the judiciary. The government's not supposed to say, hey, stupid, like the vaccine's not going to hurt you, your religious beliefs phooey. Like, that's not the role of the courts. The court is there to determine whether or not the religious belief is personal and sincerely held. There are people that want attorneys to help them perpetrate a fraud. Give me a religious reason. I'll tell you what I'm doing. You tell me the religious reasons why we can do this. I'm not interested in that game, but there's that concern. A lot of employers were getting form letters from all these employees, and some of the employees were forgetting to change the pronouns. They were just like, this attorney put this letter online, I've just adopted it, sign here. This is all the reasons that I haven't even read as to why my religion, says I can't do X, Y, or Z. And I think there is skepticism both in the court of public opinion and also in the judiciary about, well, what if we go back to this idea, the Sherbert v. Verner, Wisconsin v. Yoder, this idea that there's this solicitude that the law entitles religious observers to. Aren't we just going to erode the rule of law and everybody's going to be free to claim God told them to do X, Y, and Z? So I think that's underlying some of the pushback here and why there's still reluctance from Justice Barrett and Justice Kavanaugh and the court, and why we don't have a majority yet. And I'm very interested to hear, what your thoughts are, Mr. Hanna, where you think this may be going and how you think this might all settle. There's a chance that with the kind of revived understanding of what is and is not generally applicable, that Lucumini and Employment Division versus Smith have enough teeth and they'll just let it stay there. I think the momentum's in a different direction, but I'm bad at reading tea leaves, and I have to kind of give my best educated guess. But Mr. Hahn, since you guys are up the Supreme Court all the time, want to forecast where you think religious exercise jurisprudence may be heading, and what would unify 5 justices on the Supreme Court in this area? Because I'll give you $50 if you're right.
Well, thanks for that. Although I'm not, I learned a few years ago when life took a turn for the peculiar to stop being a betting man. So, but in any case, I do think that, like I was kind of saying before, I think this emphasis, this moving away from rigid formulas, grand unified theories, one test to rule them all, and seeing more of a family of doctrines is not only a feature of just free exercise jurisprudence, but also I think suggests how the court might think about free exercise in relation to other constitutional protections that are in the same family, let's say. You mentioned, Mr. Street, earlier about how Smith may have put some pressure on litigants to plead what are really free exercise claims as free speech claims. And you could see a situation where a reinvigorated free exercise clause puts pressure on litigants to raise free association and free assembly, what are really free association, free assembly claims, another neglected portion of the First Amendment, which Beckett has talked about at length, particularly in the Americans for Prosperity versus Bonta case. We wrote an amicus brief there that was mentioned. Justice Thomas's concurring opinion cited by multiple justices at argument. That's another neglected First Amendment guarantee. And you could see a situation where the reinvigoration of the free exercise clause kind of maybe creates a situation where what are really free assembly and free association claims aren't being conceived of in those terms. So I think what it points to, and the Barrett concurrence in Fulton, I think suggests this, a more careful evaluation of how all of these doctrines interrelate, not just free exercise doctrines, but First Amendment doctrines more generally. On the point of clarity, I do think this actually leads to considerable clarity on this kind of crucial point, which is that all 9 justices think that restrictions on religious liberty should be subjected to rigorous judicial review. The notion, not a single justice in Fulton lifted the pen to defend Employment Division versus Smith, not a single one. It was really a question over how should we think about the future of all these doctrines working together. The notion that the judiciary should be detached from how religious liberty is faring in public life is not a notion embraced by the current Supreme Court. And that is something that I think that is a great bode for confidence, particularly when you consider the fact that the way Fulton is written, the majority opinion, focusing on a system of individualized assessments, even thinking about whether it would be congruent, I believe the word from the majority opinion is, to think about foster care as a public accommodation, given the kinds of individualized inquiries in the home study certification piece of it. That's reasoning that could be extended to how a university thinks about student groups, for example, or other kind of individualized determinations. So I do think there's good reason to think that this court is going to apply rigorous judicial review to government action that is proved to be discretionary, and make sure that if religion is not being treated in a way that is commensurate with the fact that it's a Bill of Rights stated protection, that there's a good reason for it. And that gets to, I think, something else you're mentioning about one of the other questions going forward is not just putting the government to its proof, but also ensuring that the sincerity and the substantial burden aspects of the doctrine are also well tended to. There has been, I think, if you look at Fulton, like we got to a place where general applicability was the focus of that opinion after it was established that there was a substantial burden on Catholic social services religious freedom. And here in Fulton, like you had a situation where the city of Philadelphia was telling an arm of a church to speak and act despite its religious beliefs. That absolutely satisfies the substantial burden. And when Catholic Social Services has been doing foster care consistent with its religious mission longer than the city of Philadelphia has been doing foster care for over 200 years and really pioneered it in the city, there's no question of sincerity. But I do think that emphasizing that there is going to be a careful analysis of that part of the inquiry as well is important and necessary. And it's something that Beckett has put in our own briefing in terms of how to think about the burdens that a careful balance that religious liberty protects ensures on both sides of the analytical ledger. But I will say, I mean, on the piece of reversing Smith, so as I said, I think it's best to think of Smith as a residual rule going forward. And I think that's how the court's been interpreting it, as not the baseline of the free exercise clause, but rather something that applies to across the board prohibitions that are much rarer in an era of administrative action than perhaps was conceived of in 1990. But in any case, I think it's important to debunk, and Justice Alito's separate opinion does this at some length, the notion that Smith created a clear rule. The notion that an inquiry into neutrality about what constitutes neutral treatment toward religion is something that is just a threshold question, but doesn't involve a consideration of legislative history, perhaps subjective motivations of decision makers, that can be a quite cumbersome inquiry. It can also be a quite cumbersome inquiry to assess general applicability. Now, that's not to say that those inquiries are bad or wrong or inappropriate. Having a nuanced, sophisticated doctrine that realizes that religion and government interrelate in different ways is probably going to result in a more thoroughgoing inquiry. But the notion that this was simple, clear, and crisp and makes Sherbert and Yoder pale in comparison in terms of simplicity is just not accurate. I think the surer way forward, and we're seeing this especially in the Establishment Clause, but also we see it in some of the Religion Clause cases on the free exercise side of the ledger, is a return toward history and tradition. Is this the kind of relationship between government and religion that has, to quote Espinoza, another free exercise case, that is going to be informing one that the court will hear in December called Carson versus Macon, involving funding in religious schools? Is there a historic and substantial tradition for the kind of relationship that the government and religion have in this context? And how does that relationship play out? And that, I think, is an important anchoring principle that can refine a strict scrutiny analysis and keep it measured and focused in a way that provides clarity to litigants, as well as something that courts are comfortable and familiar with doing.
Great. Well, this has been a super wonderful and enlightening jazz dance ensemble. Unfortunately, we are out of time. Please join me in thanking both of our wonderful speakers.